I would like to invite Michael Karayanni to deliver his talk, which will be on the Palestinian-Arab Millets in Israel, Tainted Liberalism. Judging by Michael's surname, I could almost put my money on the fact that we probably belong to the same millet. So you would have a rather unique session where the chairman and the speaker would be of the same millet. So I'll do my best not to be particularly biased, or to make another case that Orthodox Christians like Jews never agree on the same point, so we shall test it anyway. Michael.
Thank you. Yes, it's the Greek Orthodox millet actually here. You have a number of Orthodox millets.
Yes.
Well, okay. The paper is about the millet system in Israel, the history of the Israeli millets, and when I will discuss the Israeli millets, I would concentrate on the Palestinian-Arab millets that happen to be the Muslim and 10 recognized Christian communities, and you have the Druze as well, and on top of these you also have, of course, the Jewish and the Baha'is, who are also recognized as a religious community in Israel. And before I go into the details, I would like to put this discussion in kind of a universal context and trying to evaluate the reality that we have. And I want to start with the kind of ethics of group rights, how the accordance of group rights or the denial of group rights signals some very normative, I would say, values that helps us evaluate and then try to argue that some of these normative values are a kind of an illusion, and this is how I would connect to the Israeli case. In the US, there was some discussion about affirmative action policies and whether affirmative action policies should be judged with strict scrutiny when we want to evaluate these policies. And John Hart Ely wrote a wonderful article on affirmative action saying, well, it should not. The reason he gave was, it's one thing when a majority, and in the US case, the white majority, is discriminating against its members for the benefit of minority members. So if the whites are saying, I'm discriminating against whites in order to benefit the black minority, this is one thing. But when the white majority is discriminating against a minority, this is another thing. So there is this intuition that when the majority is doing something against the interest of that majority, this implies something which is normatively more legitimate as opposed to position when the majority is doing something against the minority. Jeremy Waldron wrote a wonderful book just 2 years ago on the harm of hate speech. And he does bring out the issue of, well, maybe we should restrict the freedom of speech of majorities more than we want to restrict the freedom of speech of a minority. He doesn't go into the specifics, but as a matter of principle, he makes this argument, and he gives a lot of convincing arguments. I've written an article on the exclusion that happens in some religious schools in Israel, as well as in many other places. And I think there is also a notion, a normative notion, that says the following: if a minority community is excluding majority members or other members, non-members, from its school, this is much more legitimate. I'm not saying it's valid in all cases, but it's much more legitimate when the majority is coming and excluding minority members from its school. And in my seminar at the university, I give a very simple example. Of course, segregation in US schools was improper, But let's assume that the black community in the US wants to have its own school and it's excluding whites. That would be much more valid, legitimate than when the whites are excluding minority members. There is something that happens when we put the minority, the group, in context that gives us at least a normative intuition whether that act is legitimate or not. But there's some downsides when we put things in the context of groups, and the wonderful example is about a cultural defense, right? People would come claiming that I did this act in the name of my culture, and therefore I should be exempted from liability. And there's a lot of discussion whether this essentializes culture and groups that they happen to be of one thing, of very simple behavior, and we don't see the nuances. And so if one culture has this kind of a practice, we kind of label the whole culture with the practice, and that's essentialism. In this vein, there is also this normative intuition, and this is the normative intuition I would be discussing today. In Middle Eastern countries, in countries of the Orient, that most of these countries happens to be identified with a certain religion. When that country is granting some kind of a autonomy, some kind of a jurisdictional authority to its religious minorities, then these accommodations, this jurisdictional authority, is taken to be something which is tolerant, which is multicultural, which is even liberal in terms of evaluating the existence of such an accommodation. So if in the US you would need to really justify why the Amish, why the Native Americans should have some kind of an autonomy in terms of their school system, well, it's taken to be for granted that if Jews or Christians in Iran are granted autonomy in terms of their school, well, this is liberal, this is a tolerant attitude, and you don't need to even justify it. And so the case happens to be in Israel. Since Israel is identified with Judaism, and Judaism, according to my interpretation, is an official state religion, it's an established religion in the country. Whatever Israel grants to non-Jews that exist, to Muslims, to Christians, and to the Druze, in having this autonomy over their family law affairs, is the tendency is to see or to perceive that jurisdiction as being tolerant, as being liberal, or as even being multicultural. So in India, when there is this sense that India happens to be identified with one group and the Indian government is accommodating Muslims in India, this is taken to be something of a tolerant attitude on part of the government, on part of the state. Now, why this happens? It happens because the state itself is identified with another religion. So anything that is granted to the non-majority or to the non-hegemonic religion is taken to be a tolerant attitude. And my talk today would be split into two. I would be showing you how in Israel, in terms of religion and state, when we discuss the jurisdictional authority of Sharia courts, of Christian courts, of Druze court, in terms of religion and state in Israel, this authority is perceived to be a tolerant attitude on part of the state towards the non-Jewish minorities that exist, as opposed to another perception that happens to be more dominant in terms of the Jewish community, where the same jurisdictional authority is labeled to be coercive, illiberal, but nonetheless a necessity. So there is this two paradigms that would govern in the same state, the same jurisdictional authority, and the two paradigms come to be because of this normative intuition I was talking about a few minutes earlier. Now, after I would be exemplifying this split, these two paradigms, I would want to discuss whether it is actually liberal as it seems, or maybe it's an illusion. And my argument would be that if this is liberalism, it's tainted. Because behind these accommodations, there is an interest on part of the establishment that wants to maintain these millets, this religious autonomy, not for the benefit of the community, but more for the benefit of the institution. So if there is some liberalism involved, it's really tainted. It's not really the interest of the community that the state is involved with or is concerned about, but some other interest. And I would be discussing 4 such interests. And this will be the topic of the second part of my presentation. So let's start with basics. If you open any book on religion and state in Israel, if you open any article dealing with religion and state in Israel, you would find the discussion exclusively Jewish. You would find the discussion really centered on the conflict between the recognition accorded to Jewish religious norms and institution on the one hand, and what can be labeled broadly liberal democratic norms on the other hand. So how should we manage this conflict? And this is religion and state in Israel. This is so dominant that when I opened one of Israel's main commentaries on constitutional law, when I was asked to comment on that commentary, and I went to the subject interest index in order to find where religion and state is discussed, I found the following entry saying religion and state see a Jewish state. You won't find any discussion on the religion and state, the same conflict in terms of the Palestinian-Arab millets. Now, in terms of jurisdiction, one should even mention the fact that until the year 2000, the jurisdictional authority of Sharia courts in Israel was the broadest authority, even vis-a-vis the rabbinical courts. It had exclusive jurisdiction to deal with marriage and divorce, but also with alimony and paternity and a number of other family law matters, when the jurisdictional authority of the rabbinical court was just over marriage and divorce in terms of its exclusive jurisdictional authority. And when you look at the jurisprudence of the Israeli Supreme Court, all throughout its history, you would find a lot of discussion dealing with the Palestinian Arabs in Israel in terms of their accommodation. So in the early 50s, you had a big issue with polygamy. Is criminalizing polygamy an infringement on the freedom of conscience of Muslims? And there was this big fuss about polygamy. You would find another case involving Christian communities dealing with one such matter, that the appellate court of the Catholics and the Maronites happens to sit in Lebanon, where the litigants happens to be here. So they were asked to file their appeal in Lebanon, and the Supreme Court had to deal with whether this is something that can stand, because in terms of access to these courts, there was no access. You couldn't cross the border into Lebanon and appear before the court. After 1967, you had this dilemma, okay? You had just a few blocks from here, you had Christian courts sitting, and they had jurisdiction over Christian courts sitting in Jordan and in the West Bank. That is, courts that Israel now considered to be sitting on its sovereign territory has jurisdiction over courts sitting in some foreign territory. Is that something which is possible? And the Supreme Court handled these issues. Now, these are very religion and state, but you don't find any of such a discussion in the literature. And I can go on giving you a lot of other examples where you find this conflict between sovereignty, human rights, individual freedom, autonomy, jurisdiction, but you don't find it really in the discussion. And then I ask myself, why? My thesis is that there is two paradigms that happen to govern religion and state in Israel. One paradigm that happens to govern more in terms of the Jewish majority, and another paradigm that happens to govern in terms of the non-Jewish minorities in the country. In terms of the Jewish majority, religion and state is connected to the identity of the state of Israel as a Jewish state. If there is legitimacy for having jurisdiction of the rabbinical courts, of the religious councils, of having exclusive jurisdiction in marriage and divorce among Jews, it's about Jewish identity. It's about maintaining some kind of a Jewish identity that the state takes to be its objective. So Judaism in Israel is not just like any other religion. It has a public presence, and Israel takes that religion to be part of its identity. This is not true in terms of non-Jewish religions in the state of Israel. Their presence in the state, if Israel conceives there is a legitimacy, at least the official policy, is that this is something we want to grant our non-Jewish minorities that live among us. And you would find that jurisdictional authority depicted as being something which is tolerant, making Israel, even in the international community, brag and take pride about it. And there's this text in 1961 by the Israeli Foreign Ministry that says the following: comfortably with the injunctions of their faith, the law vests in the religious community's authorities in matters of personal status. And these religious courts are the Arab religious courts. In fact, the Muslim and Christian religious courts have jurisdictional powers exceeding those of the Jewish rabbinical courts. This is the foreign ministry in Israel speaking. It's bragging about this authority. This state of religious judicial autonomy continues to be maintained in Israel. Lately, indeed, it has been extended to the Druze community. So if there's a new community that wants the jurisdiction, we extend it. And Druze religious courts are now being established. At the same time, an entirely different process has been taking place in some of the neighboring Arab countries. In Egypt, for instance, Sharia courts and the courts of other religious communities were abolished in 1956, and their power transferred to the civil courts. This is the foreign ministry speaking about Egypt. It's like condemning Egypt. Look what Egypt is doing to the religious courts, and look at us, we state what we are doing. So Israel officially is really taking pride. And this is the essence of this conception that if I would be speaking in the name of the Jewish state, we're affording this accommodation to the non-Jews because we are tolerant, we're open, we're liberal. And the foreign ministry was not commending Jamal Abdel Nasser in 1961, the arch enemy of Israel. It was condemning Jamal Abdel Nasser for what he has been doing, abolishing the courts. But when you turn to the narrative that would be discussing the jurisdictional authority of the rabbinical courts, it would take another turn. It's coercive. There was even, I found out there was this organization against religious coercion that happened to exist in the 50s, and it was abolished or came to end in 1967 in Israel. And that was concerned only with the Jewish rabbinical courts. It didn't handle the non-Jewish communities. And so when you speak about religious coercion, it's also very much about what happens within the Jewish community. I can go on and on. Secularism in Israel. If you take Guy Ben Porat, who wrote a book on the secularization of the Israeli society, it's Jewish-centered, even secularism. If you take secular parties in Israel, advancing an agenda, it's very intra-Jewish. It doesn't deal with abolishing Sharia. It deals with abolishing the rabbinical jurisdiction. It's tending to the problems of the aguna within the Jewish community. judicial activism in terms of religion and state. If you see all of the text dealing with judicial activism, it's more concerned of what the Supreme Court is doing to the jurisdiction of the rabbinical courts. But never you would find a discussion dealing with judicial activism on what the Supreme Court is doing to the Christian courts or to the Sharia courts. It's all Jewish-centered. And I think it's all Jewish-centered because there are two different paradigms that govern the justification why Israel has this jurisdictional authority. And since, in terms of the Jews, it's connected to the identity of the state, and since, in terms of the Palestinian-Arabs, it is a multicultural accommodation, these two do not mix. It's like mixing water and oil. And since they do not mix in terms of how you perceive them, you cannot discuss them together. And therefore, they're separated. And the discussion is really a schism. It either discusses this or that, but never together. Now, what was of interest to me, and this, what I've just said, builds on some of my earlier work, was to look into the history. If we go back to 1948 and look into official documents of the government, was it really the interest of the community? Was it really this tolerant paradigm that dictated this policy, or was there something else at play? And when I started looking up documents in the Israeli archives, a lot of things became apparent that before that, they were not. This is very much discussed here, because if you would try to see what was the history of the recognition granted to the Jewish religious institutions, you find a lot of theories, right? Some would say it's government coalition. Some would say it's conflict management and consocialism. We need to manage the conflict between us, secular and religious Jews, so let's agree on having something and not doing other things. You would find discussion, this is something we need for our Jewish identity, and we cannot change this jurisdictional authority. But nothing discusses why did Israel maintain the Palestinian-Arab Millets? Is there something else at play? Because all of what I've just said are once again very much Jewish-centered. They don't offer any kind of an explanation as to why Israel maintained the Sharia courts, the Christian courts, or is so accommodating in terms of recognizing new religions like the Druze and the Baha'is later on. And here I offer three explanations, which I think kind of explains why Israel maintained the Palestinian-Arab Millets. These are not exclusive, but I think they are very much special to the Palestinian-Arab Millets. One explanation I call the balancing formula. If you would look into the documents that Israel in 1948 based its legitimacy on, starting with the Balfour Declaration, the San Remo Conference, and the Partition Plan, you would find this connection between the recognition that is afforded to a nation state, but then in the same text you would find that this needs to be balanced off by some recognition given to minority religions. So it's in the Balfour Declaration, it's in the San Remo Conference, it's in the Partition Plan, and in the Partition Plan it was kind of equalized. If there would be an Arab state, it should recognize minority religions, and if there is a Jewish state, it should recognize the non-Jewish minorities within that nation state. Now take into consideration that in 1948, Israel had a very tough legitimacy problem. It based its inception on the Partition Plan, and it was very cautious in terms of articulating its foreign policy according to these documents. So it wouldn't mess with this balancing formula if it's basing its legitimacy on these documents. And it was very evident even in the war in 1940. Uri Byaler from the Hebrew University wrote a book, The Star of David on the Cross, he called it, and he analyzed Israel's foreign policy. And there was something to be happened in Nazareth. Supposedly and allegedly there was an order to expel people living in Nazareth, the local Palestinians. And that order was abolished by Ben Gurion. He was very fearful. If we will do this in Nazareth, how we would be seen in the Christian world when we are seeking the legitimacy of Europe and in the US. And you would find that even very much present in terms of the policy of how Israel handled Christian property in Israel. Okay, the Israeli Knesset is sitting on Greek Orthodox land. A lot of very strategical property is held by the Christian churches here in Jerusalem. But Israel never bothered, or couldn't even, at least from its foreign policy, to do anything about this property. So because of the concern how it would be perceived in the international community when it was seeking legitimacy from foreign powers. So there was this very strong notion of having a balancing or fulfilling this balancing formula. Another issue which I found was the divide and conquer issue. Now, a lot of people wrote in books that the more you are able to divide the local minority, which you would conceive as a threat, the better you are able to control that minority. And Ian Lustig, control policy, a lot of people writing on the local minority in Israel stated that there was this divide and conquer, and the Millet system proved to be a kind of a natural treasure. It divides this Palestinian-Arab minority into all of these millets. So if we will maintain these millets, we are dividing or maintaining the divides, and then this is facilitating the establishment's policy of control. But when I looked into the sources, what were their citations, I couldn't find any specific example. So I went into the archives and I found something which was fascinating, which really proved that this was an issue. In 1948, there was a minister who was the Minister of Police, but was also the Minister of Minority Affairs, and his name was Bechor Shalom Shetrit. Now, Bechor Shalom Shetrit was considered to be rather very open, very liberal, and wanted to do a lot of things beneficial for the Palestinian-Arab minority inside of Israel. And he even offered something which today would seem really very, very considerate of minority interests, which was proposing a public council that would assist him as minister to conduct the affairs of the minority. And that public council would also consist of minority members and advise the ministry and the government on how to handle the minority affairs. And he put together this ordinance, and he sent it to the Ministry of Religions and to the Ministry of Education, and he invited his colleagues to comment. And then you would see how the comments developed. And this is the Minister of Religions writing to Shetrit. And he says this, I would read it in Hebrew and then I would translate. He was very against the idea. את הטיפול בענייני תרבות וחינוך יש למסור לבני העדות השונות. מדיניותן ושאיפותיהן אינן אחידות, כי מטרות אחרות יש לעדה המוסלמית ואחרות לאנשי העדות הנוצריות על כל גווניהם. אין זה מתפקידנו להטביע על תרבות זו וחיזוק זה את חותם הלאומיות הערבית. He's saying it explicitly. It is not our job to nourish Arab identity. It is our job to maintain the identity of these different communities. I can go on and cite some more records. Yeah, okay. It was cited to be a dangerous precedent by another official, and the bill will consolidate Fishman, the minister. The bill will consolidate the different religious communities in the country into one national minority, and this is a threat. And it goes on and on. So maintaining the millets would facilitate control, and this is also something that Israel wanted to do. A third factor was that there was some concern about Jewish identity, and it came up in terms when the rabbinical court's jurisdiction was devised. If there would be no millets in the state, there is this threat that Jewish identity would be lost, since there would be mixed marriages and interreligious marriages. And so we would need to consolidate the religious authority in order to maintain the divide as to not to weaken the identity. Tzvi Trigger wrote about it in a very persuasive article. It's well documented. Zerach Warhaftig is on record. What defines Israel as a Jewish state? In his language, it's three things. One is the law of return. The second is the law on marriage and divorce. This is what defines Israel as a Jewish state according to him. The third law is about Sabbath. But maintaining exclusive jurisdiction of the rabbinical courts is something that maintains, excuse me? Yeah. It maintains Jewish identity, and divide would facilitate that. So if you would take these into consideration, if there was some liberalism in terms of maintaining these millets, I think it's tainted. And this would kind of bring us to reevaluate if there is this jurisdictional authority of minorities in other countries which happen to be identified with one state. I would want to caution, and this is the basic argument, that what seems to be liberal because it's accommodating to minorities, if you look into what really exists behind this authority, it does not necessarily comply with what we define as being liberal. Other forces, other things might be existing. Thank you.
Thank you very much. Gavin Monskin.
I'm going to debate some of Mikhail's point. First of all, I want to point out, just, and it's not connected, that this land on which we are sitting now, right now, originally belonged to the Greek Orthodox Church. It was expropriated by the British government in 1938, and the British paid the Greek Orthodox Church the sum of £1 million, which is a very large sum of money in 1938, because they wanted to put their government here. That's just to point out what the exact history of this land that we're sitting on right now is. Now, the second point is that when I was
why is this telling?
I'll tell you in a minute.
Okay.
And then the second point is that when I was growing up in America, I remember that people asked me why I don't celebrate Christmas, because they said that's a secular holiday. And the question is always, what is the exact interface in a majority culture between religion and secularity? Because it was assumed that I see this in Van Leer, where I campaign with my staff to celebrate minority holidays. No, but Pesach, Passover, and all the others, these are national holidays. Nobody sees them as religious holidays. So there's some sort of slide between what is secular and majoritarian culture, which I think is fairly universal. And I think that leads to the next point, which is that the real danger and problem of the millet system, wherever it has existed, is not of the religious population, it's the secular population within the religious population. What do you do if you are a secular Jew, a secular Muslim, or a secular Christian, and what kind of authority can you go to? And now to my main point, which is this. What you're arguing for, Michael, is that the State of Israel should somehow have abolished the millets, because the abolishing the millets would be the more liberal move. Well, where did the millets come from? It's not that there was a millet out of the blue. There were Ottoman millets. The whole arrangement was continued by the British government and then continued. And what the State of Israel did, and this I would argue is the main reason, they had no idea of what to do. They kept the mandatory laws in all spheres until they slowly reformed them, so that as late as the 60s, Israeli land law was Ottoman land law. And in other words, the laws, the rebus sextantibus, meant that everything that existed before was preserved as of the point of the new state. So what you're asking for is for them in this area, exceptionally, to create new law where they had not created new law in other spheres. Now, your argument, I think, would be better if you would say, no, in fact, this millet system has outlived its usefulness. Let's abolish it now. That argument, I think, would be valid. But it doesn't have anything to do with what went on then, which we existed in the same way in every single sphere, whether it attached to a minority or not. Because I would say that in all cases, they were not, because their basic thing is that they had to have a cause for modification, because they didn't modify land law, they didn't modify criminal law, they didn't modify any of the spheres of law. The only laws they modified were certain laws like the law of return took till 1951, or the law of, of the idea that Jews could have the law of return. It also wasn't right away. It took till 50 or 51 or 52. I don't remember. But it was sometimes in the early 50s, and they very slowly began to legislate laws. In those years, as you know, there were no basic laws. The basic laws came in much, much later, and the last laws that were modified, as I remember, correct me if I'm wrong, were the land laws. And that was, a long time later. That was like a half generation or something later. So I would say that it's not that your reasons are wrong, but I think that they contribute to the main reason of what I would call jurisdictional inertia, which is maintaining the system. Now, what you have really proved, and I think that's the important point, is that the millet system may be pluralistic, but it's not liberal. That I would agree with you. I don't think there's any question about that. A millet system is by its nature not based on individual rights. And that was true of the Phanariots in the Ottoman Empire, the Phanariot Greeks in the Ottoman Empire, and it's true today. And if you want to make that argument, I completely agree.
Let's collect a few more questions.
Okay. Yeah. Yeah, in the same...
You turn it on.
It's on, I think. In the same line, I remember there was a decision some years ago in which the Supreme Court intervened in the millet principle of inheritance and said, no, whatever the Jewish law, I think it was Jewish law of inheritance was, it was discriminatory and we won't follow it. Now, if they had been following the strict millet system, they wouldn't have done that. They would have simply deferred. But when it came to a high level of principle, maintaining equality between the sexes in inheritance, they intervened. Now, my question is basically, when the court decides to do that, because there is a conflict of laws, this is your field obviously, there's a conflict here between the secular law and the millet law, and they make a decision, no, the principle of equality should prevail, doesn't that apply that it cuts across the board to all the millet systems, not just the Jewish millet system? So it cuts across the board, and therefore they're regulating all of them. So if they decided, for example, that the principle of the Aguna system was a violation of a principle of equality, no religious millet would be able to maintain a unilateral system of divorce. That's the first question. But then I wanted to ask you conceptually, this is a very strange, it's a difficult idea to understand, and I think we'd have to go back and find out, well, where did the Ottomans get this very strange idea? Is it something like the American constitutional idea of public and private? Is the idea basically that the inside the millet was supposedly a private sphere that be regulated by the community and not by the state? But then you have interesting questions about the Dayanim. Who are these people? And are they appointed and controlled simply by the local community? That doesn't seem to me possible. So there are lots of interesting questions that come up at the intersection.
Last question from Joseph.
Thank you, Mikhail, for the presentation. Just, well, my comment is that I wonder if we don't find in your presentation a mixture of two distinct problems, one of which I could describe as the politics of identities. And the parameters are obviously minorities and majorities, as we term it today, the problem of accommodation. Now, as the problem of accommodation was articulated in the UK since 2008, since the famous address of Reverend Williams, regarding Sharia courts, maybe we are mixing a different problem, and I think in the same line with Gabi beforehand, the problem of jurisdiction. The problem of jurisdiction could be seen as totally a jurisprudential one, and we talk here about three distinct jurisdictions. First of all, obviously, the territorial, and then the millet, and then the personal status in family law. Now, I insist on making the distinction between the millet system and the personal status issues, mainly following some comments of Talal Assad in his book on the Reformation of the Secular, where he tries to trace the idea of personal status, mainly in Egypt, back to the Napoleon Code. And for him, it's part of the endeavor to privatize law to the extent that it becomes individualized. In that sense, I don't think it's the same issue. And as Gabi might mean before, the problem of personal status might be also a problem for individuals within the majority of the community. As you can see, these are for Jews who are not accepting the rabbinical courts, they suffer from the very linkage of personal status and family law. So I might raise the question, perhaps the millet idea might come from a different origin than the idea of personal status, which at some point they did merge and create the current reality. In that respect, I also agree. The problem is with liberal principles, human rights, the place of individuals, but not necessarily minority vis-a-vis majorities. Thank you.
I can start again. I mean, these are certainly very challenging questions. My assumption is that you can have the same system in the same state or in different states, but then what stands behind that system can be a different kind of objective or justification. So if the Ottomans had this system and the British maintained it and Israel maintained it, it doesn't mean that it's out of the same reasons. You would have different reasons or can have different reasons in all of these different periods. Now, in terms of Israel, and in terms of the context, you should take into consideration that the Arab minority inside of Israel in 1948 was only about 12% of the population. To be exact, it was about 12.5% of the total population. It was eliteless. There was no elite, no intellectual elite. In terms of politics, there were no really Arab parties other than the Communist Party. Politically, they were powerless. In terms of the government, it did consider having a territorial, secular law in terms of family and marriage and divorce, and there was something put on the table. And there was a quest of making territorial laws in the 1950s, and some of these did really make it and become laws in the 1960s and in the 1970s. So in terms of dealing with this minority, I think the government was really powerful in terms of dictating one territorial law in marriage of divorce and abolishing the millet without even having any concern in terms of this minority objecting or this minority leveling any political resistance. This is my assumption, but nonetheless the government did maintain this system, and I'm asking why. And I'm trying to come up with reasons that are not exclusive. I'm not saying that these are the only reasons. What I'm trying to say is that there are a number of considerations that happen sometimes to even overlap, an overlap consensus. You can have different reasons why you maintain this system. And what I tried to do is to highlight 3 different factors which I think I could prove, and I have the documents, where this was maintained because of what I was trying to say. And this happens to be different of how the British handled the same system and different from how the Ottomans handled the same system. So that's the argument. I'm not saying that they happen to be exclusive. I'm not saying that the concern about maintaining some order in the country is invalid. I think it was also one valid concern, but it wasn't the only concern, but there were other concerns, and this is what I have been, and that's why I'm not saying it's illiberal. I'm saying it's tainted liberalism. It's liberalism, but it's tainted. It has other things, because I think if you would have asked the Arab minority at that time, you're for or against, I think they would say I'm for. And I can have also other reasons, and this is something I'm researching at the moment, that it's a control policy by the minority leadership itself. Because the minority itself, as much as the Jews didn't want to mix with the Arabs didn't want to mix with the Jews. So it was also serving this policy of maintaining the Millets, since Israel is a non-assimilative society, and the Millet serves that objective. So that's the argument. Now, in terms of liberalism, as George was implying, it's true. But when I studied all of the Supreme Court decisions, I found this: there was never one decision of the Israeli Supreme Court touching upon the jurisdiction of a religious court, where liberalizing that jurisdiction would happen first in the Sharia or in the Christian, and then it would be applied to the rabbinical court. It always happened first in terms of the rabbinical courts, and then it is applied by virtue of precedent to the non-Jewish communities. Now, why does this happen? And I have Supreme Court justices on record. Because in terms of the perception of this Supreme Court justice, when I perceive the jurisdiction of the Sharia court as liberal, and I happen to be liberal, I don't push with full force in liberalizing that jurisdiction to be for the individual against the community. I would be at best split into 2. But if I'm Ahron Barak and I'm a liberal justice, and I perceive the jurisdiction of the rabbinical courts to be coercive and liberal, and I'm very liberal, I would be pushing with full force against the jurisdiction of the rabbinical courts. And therefore, in terms of history, looking at it from a bird's eye, you would always see that liberalization of the norm first happening in the Jewish community and then applied by precedent to the non-Jews. But it's never the other way around. I can go into details, but don't want to take too much time. But
yeah, well, we